Leave of the court. Item number 34 of the Lordship test list.
Yes.
In fact, there is no caveat in the matter, but matter is having a lot of urgency.
Hold on, let me finish up with this.
I missed the item. In fact, the trial court has fixed the date on 28. If your Lordship kindly
28th of January.
If your Lordship kindly take up this matter
let me see how far I can proceed. Yes.
My Lord,
may I be permitted to mention one matter for inclusion in the list, my lord?
What matter?
This is a matter. This is a matter. This is a matter.
Writ or civil?
Writ, my lord. Writ.
Petition of the year
2000, my lord.
my Lord, kindly, my Lord, 2007 matter, my Lord.
2007. You have served notice upon the other side. You have served notice upon the other side.
I have already served. I have already served. I shall.
No. Notice of mentioning. Notice of mentioning. Have you served?
Lord,
have you given any notice of mentioning?
Lord, I gave the notice when the matter was appearing in the list of Honorable Mr. Bhardwaj. Lord, I shall.
No.
Lord, I shall. My lord, I shall.
Mention after serving notice. Where is your notice?
Notice, my Lord. Served.
All right.
Eternal.
Mention after serving notice. Yes, call the list.
My lord, may I have your lordship's kind?
Item number?
28 of your lordship's list.
Yes.
Just because of your lordship is to direct us to serve a copy upon the opposite party. That we have served, we are understanding the expeditious disposal matter.
Let me see. Let me take up the list. Let me complete the list. This was called on. None was
there on the day before yesterday. It has been included yesterday. And yesterday your lordship has been pleased to call it.
It was included yesterday only. All right.
My lord, may I have
Item number 112 of your lordship's today's list, my lord. This is that matter, my lord. I have notified, my lord, again upon
let me see how far I can proceed.
My lord, may I have your lordship's kind
Saturday
leave?
is the date. Saturday is the date.
Yes.
Lordship's kind leave to mention a matter, lordship's previous determination. It was that matter whether the retrospective effect of the pay could be.
I do not have
Your lordship
determination
doesn't
now.
have the only lordship. I was humbly, but we'll mention the matter before the regular bench and get it try to get it released. And place it before your lordship and ask for an assignment before your
That
lordship.
is up to you.
My lord,
That is your choice.
provided your lordship is inclined to take it up. That's the only reason we are mentioning.
Up to you. You can take any course, but
Lordship,
yes.
may I be permitted to mention one CEO matter for upgradation, Lordship. Appearing is
Your matter for
upgradation, Lordship. Appearing is item number 69, Lordship. Today,
item number 69.
in today's list, Lordship. Lordship, the urgency is that the under section 6 application under the specific relief act was filed before the learned court below, and in that
69, where were you yesterday? It was taken up yesterday, called on yesterday. Item number 69 was called on. It was the last matter which was called on yesterday.
Lordship, not monthly list. In today's list, daily list is appearing as item number 69. Lordship.
Yesterday it was called on. Yes, call the list. Extension of interim order. Yes. Call the list.
Item number 2.
One হবে না? Your lordship. Madam for the petitioner.
Yes, you are appearing.
This is my application, my lord, for contempt of the honorable court's order, which I have annexed, my lord, in the
For the alleged contempt, you have received the contempt application.
No, I have not received, my lord, but I am candid before your lordship, my lord. In terms of your lordship's order, my lord, the hearing was conducted.
Yes.
May I please?
Yes.
But
Mr. Rai, let me hear him.
And 23rd March 2023, my lord, order has been passed by the commissioner. Now, my lord, what is the...
Have you communicated the order to the petitioner?
Yes. Now, my lord, what is the case?
Yes or no? Have you communicated?
I shall check it up, my lord.
Yes.
With the report, with the, my lord, whether I have served or not.
Now, what practice you are following? The contempt application, you are refusing service. Kindly see this.
Yes, why, my lord? My lord. The predecessor, my lord, so Dr. Soumitra Mohan, my lord, he is not here now. Now, my lord, new incumbent has come.
That is by refusal.
My lord, so far my knowledge, my lord, it is happening in this way that by name it was sent. So, my lord, the name, the parties is not there. Therefore, that was, I think, my lord, right? So, no.
Advise your clients
But, my
accordingly.
lord, my lord, now, my lord, the new incumbent has come, my lord. This is
Yes.
my candidate before your lordship, my lord.
So substitute him.
Yes, I'll do that.
But when the order was passed, who was there? The new incumbent was there?
No, no,
Or
no.
the earlier person?
Earlier one was there.
Earlier.
So let it remain. Whether he has
Now,
whether he has violated, that is to be seen.
no.
Why?
I'm candidate before.
It
your
was
lordship,
within
my
a time. Whether that was within the time, whether it was communicated,
lord. My lord,
But,
that was the direction.
my lord, my lord.
No, it
I
was
shall come back
violated
with
by
the
him. That
complaints
is one of, this is one of my grounds. But
You
I
add the new incumbent
I'll do that.
also.
I'll do that, my lord.
Yeah.
Here, my lord, this is my lord,
Uh,
80-year aged, my lord, person before your lordship for the pensionary benefit, where lordship has been pleased to direct that the unmarried and the widowed daughter is entitled to get. They say by the reasoned order that it is before the larger bench, so I cannot say anything.
That is
My lord,
then you
larger
have
bench,
to-
my lord, larger bench also, my lord, gives direction in my favor.
Let me see that order. The learned advocate appearing for the alleged contemner. Acha, tar aage likho. So you are representing the new incumbent, not the earlier one.
My lord, both of them. My lord.
Both of them? So
Thank
retire
you.
kore gache.
The learned advocate appearing for the alleged contemner submits that a new incumbent has joined
May I get the name, my lord?
post of Commissioner of School Education. Post up. On the prayer of the learned advocate for the learned advocate on record of the petitioner, leave is granted to the learned advocate on record to implead the new incumbent as a party, as an alleged contemner in
Yes.
the party, as an alleged contemner in this contempt application. Just a paragraph. The learned advocate appearing for the alleged contemner number 1 submits that the order submits that pursuant to the order dated. What is the date of the order?
My lord,
Uh,
your
twen-
lordship's order, my lord,
25th
January.
of January 2023.
Yes. January
2023.
January 20, 2023.
Yes, 25th.
January 20, 2023. A hearing was conducted.
January 25, 2023.
January 25, 2023. A hearing was conducted and an order was passed on.
My lord,
January itself.
my lord, hearing was conducted in terms of your lordship's order, my lord, 9th March 2023, my lord. And
An order was passed.
order was passed, my lord, 23rd March 2023.
An order was passed on 23rd of March 2023. Sir, the learned advocate, however, could not answer the query as to whether such order was communicated to the petitioner. Full stop. Be that as it may, do you have a copy of the impugned order?
Yes, my lord.
But I have a copy of this because
You
it
have a
is
copy?
communicated to me. I have annexed in my
Communicated.
I have annexed in my contempt application that.
Color ওটা লিখে ছেড়ে দিন। Whether it was communicated to me, ওটা ছেড়ে দিন।
My lord, copy may be
If I-
served upon me so that, my lord, I can.
Serve him a
Yes,
copy of the
my-
contempt application.
I have already. I'll once again do.
Learned advocate on record of the petitioner is directed to serve a copy of the contempt application upon the learned advocate representing the alleged contemner. In course of this week,
My lord.
list this matter after a week.
My lord, grateful.
Grateful.
Next.
Item number 1, below 1, item number 1.
Arup Sengupta বললে না?
There is no discharge, heard by the lordship, my lord.
Who is there? Contempt.
My lord, contempt.
Yes. Item number 1 টা call করুন।
Copy has been served upon him as per your lordship's direction.
Yes. What is the instruction?
Item number 1.
The order was passed when we were not there, my lord. The thing,
Order was passed?
when the state was absent, my lord. and,
Yes.
My lord, your lordship was pleased
So
to.
ex parte order need not become.
No, my lord. I am not on that, my lord. But your lordship was pleased to direct the DI of schools to substantiate the period of service to be treated as a 10 years for granting him the pension. But it's a policy decision. The DI has no role to play. Because the commissioner or the principal secretary or have been.
I do not know anything.
So, my lord, I cannot. I have been directed.
No, your
The
lordship.
DI has directed.
File an affidavit to that effect. I will consider
Condone
that.
the delay.
There is no scope there, there is no passing order. So,
Your
no,
Lordship
there is
has
no-
I will not modify the order. You take,
Yes.
no, my lord.
you take a stand. I will decide that.
My lord.
If I hold that you are in contempt, you are in contempt.
Yes, yes. Grateful to you.
Well, I am ready and willing to, but my hand,
That is up to you.
yeah, as a
Whether you accept this order, you challenge the
I
order,
have
that
to
is
accept this
up
order.
to you.
I have to
If you accept the order, you have to take steps.
Grateful to you.
Yes, how much time?
at 4 weeks, my lord.
Not 4 weeks. As prayed for by the learned advocate for the alleged contemner, list this matter on
My lord, may I, my lord.
February 22, 2024.
My lord, may I, in the meantime, my lord, may I serve an may I file an opposition to that?
No.
Kindly grant me that leave, my lord.
You want to file an opposition? All right.
On that point only, my lord.
Not on that point. In all.
In
And I
all,
will consider that.
in all, my lord. As your lordship.
Yes. The learned advocate appearing for the alleged contemner prays for leave to file affidavit in opposition. That affidavit in opposition be filed within a week from date. Reply thereto, if any, be filed within 3 days thereafter.
My lord,
List this matter. Yes, you are ready with the
my lord,
affidavit.
my lord.
You have your points ready. File within a week.
My lord, 1 week will be.
Compliance 4 weeks. Yes. Affidavits 1 week.
My
You are ready with your points.
some more days, my lord. It will be so harsh, my lord, upon me, my lord. But kindly, my lord. At least
When the order was passed,
Lord of-
when
Lord of-
the order was passed,
Lord-
what prevented you from communicating it? This decision, it cannot be complied with for this reason. This is a contempt. I will hold you in contempt for that.
First of March order.
File an affidavit. File an affidavit within a week.
my
My lord.
3 days.
My lord.
List on list this matter on February 1, 2024
My lord.
under the same heading.
Grateful to you.
Yes, next.
Item number 4. Item number 4, my lord, I am appealing for the petitioner.
Yes, Mr. Jari.
Yes, my lord, on the last day, my lord posed me a question, my lord. When did whether the report submitted by Bill to Ghosh, my lord kindly recalls, was
Yes, on the earlier occasion.
is before the court or not? Yes, my lord, the report of the Bill to Ghosh is submitted before the court, but not taken on record because he died prior to that. Now, my lord, the report which was submitted by Bill to Ghosh is, my lord, with respect to, my lord, the not the entire residential premises of the trustee.
That I cannot look into it. Since it was not part of the record, I cannot look into it.
Yes.
Yes.
Now, my lord, what happened, my lord, after the death of Bill to Ghosh, my lord, an amendment was carried out, my lord, by the plaintiffs, my lord, taking out from the plaintiff the requirement, personal requirement of the trustees. My lord, plaintiffs are the, my lord, DTs, my lord, who seek for requirement of the DT. Now, my lord, after the personal requirement of the, my lord, plaintiff was taken out from the plaintiff, and, my lord, the second application for commissioner was made by the plaintiffs once again, where, my lord,
The suit is for requirement of the DT.
DT.
So where the DT is at present situated?
Yes, at present the DT is in the Thakurghat, my lord, of the plaintiff of one of the trustees.
Where is that? Show me from the plaintiff. Where the DT is situated? At present, where Shiva Puja is being
Yes.
conducted? Show me that.
My lord, kindly takes the unamended plaint first,
No, now after amendment, why unamended?
because the premises which is
After amendment, you stick early whether to proceed with the unamended or with the amended.
with the amended plaint.
Show me that your statement with regard to where the Shiva Puja
Kindly
is being
takes
held.
up page 66, my lord, which is the unamended plaint.
Unamended or amended?
Amended plaint.
Amended plaint, yes.
66, page 66.
Show me how the property was bequeathed.
Yes. Now, my lord, kindly turns to, my lord, paragraph number 3.
Yes.
By the said will, the testator above name created Devottar amongst other properties, premises number 9, Ramthanu Bosle, Calcutta 6. Some landed properties at village Kalachhara, PS Chonditola, district Hooghly for Seva Puja of Sri Durga Mata Thakurani and Sri Lakshmi Mata and other deities, and appointed his two sons.
So these premises number 9,
Yes,
as well as these landed properties were
part
the
of
purpose of
deity. And
both these DTs.
yes, Yes.
Yes,
And my lord, this 9 is, my lord, the suit premises from which eviction is being sought for.
yes.
Now, my lord, kindly turns over the page. My lord, the paragraph starts from the reasonable requirement which is being sought for.
No, show me where the DT is at present situated. Where from you are carrying on Shiva Puja. Show me that from the plaint. Because at present the Shiva Puja is being held,
Yes,
the
yes,
DT
yes.
is being installed where?
Yes. My lord, kindly turns to paragraph number 16,
16.
16.
Yes. 16.
The plaintiff states that the ancestor of the plaintiff Gopal Chandra Ghosh, since deceased, created the aforesaid trust for Shiva Puja of goddess Durga in ancestral house of the deceased at Kalichara district, Hooghly, and for Shiva Puja of goddess Lakshmi in Kolkata. Though the said puja was carried on over since the lifetime of the said Gopal Chandra Ghosh, said goddess Lakshmi has no fixed place or temple, and only premises number 9, Namtanu Boshlane, is the property of the deceased.
No, where from presently it is being carried on.
Yes, thereafter,
Show me that portion. You did not place the entire plaint. Fast, Mr. Chatterjee, motion stage.
yes, yes,
Yes.
but that is pleaded.
Where in which premises?
But in premises number 42, that is pleaded in the application for local inspection.
No.
That
That
is
we
there.
cannot go.
But in the
In the
plain,
plaint, local inspection application will be not be decided in the suit.
yes,
So show me from the plaint what is the case made out.
22.
না, কোথা থেকে হচ্ছে নেই, প্লেস নেই তো, তো জায়গা নেই সেটা বলছি। তো প্রেমাইসেস নাম্বার 42 থেকে নিত্য পুজো হচ্ছে কিনা সেটা প্লেনটা বলেছে।
সেই ইনকমপ্লিট রিপোর্টে কিন্তু দেওয়া ছিল যে ঘর ফরওয়ার্ড হচ্ছে
So, my lord, in the plane, it's carried
That
on
was the
from-
pleading.
so
As
for-
to from where it is being
Okay.
carried on at present.
At
Thank
present.
you.
But
Yes,
DT has no
what
place.
is the case made out by the defendant in the written statement apropos this?
No, defendant said that it has enough space because initially, my lord,
No. With regard to the Shiva Puja and other things, what is the case made out?
the defendant
written
says
statement.
it has enough space, my lord. Kindly takes up the written statement.
Show me only that paragraph with regard to where from the Shiva Puja is being conducted.
Because written statement,
They have filed an additional written statement.
yes, my lord, that is to extend my pleadings were taken off, not that much, but the original written
All right,
context.
place from the original written statement. With regard to that, you need not place the entirety.
To 16. My lord, kindly turns to paragraph 26.
Paragraph?
Number 26 in the written statement starts from, yes,
page.
written statement starts from page
Yes. I've got-
31, page 40.
Yes, page 40.
My lord, my paragraph 16 is, my lord, in the plaint is the DT has no place.
Yes.
Now, my lord, with reference to paragraph number 16 of the plaint, this defendant states the ancestor of the plaintiff was since deceased create the aforesaid trust for Shiva Puja of goddess Durga in ancestral house of deceased at Kalachara in district Hooghly and save for Shiva Puja of goddess Lakshmi at Kalachara district Hooghly. These defendants further deny and dispute the safe puja was carried on ever since the lifetime of the said Gopal. It is denied that goddess Lakshmi has no fixed or place or temple and only premises number 9 such and such. This defendant further denies and disputes that by resolution, the trustees of the plate have unanimously decided that premises number 9 is reasonably required for establishment. My lord, there is no mention in my respect of the premises which I am alleging, my lord, is of the concern. Nowhere.
Yes.
Nowhere.
Have you produced this document, this instrument
Yes.
before the court?
Yes. My lord, my will by virtue of which this Devottar was
That is on
created.
record,
Yes.
that has been placed.
Yes, that has been placed.
Yes.
Now, my lord, what happened, my lord? Initially, my lord, as the requirement of the trustees were there, 48/2 Ramtanu lane was, my lord, allowed to be inspected in its entirety. But initially, when the first commissioner was appointed at the behest of the plaintiffs, it was always the case the Lakshmi is in the Thakurghar of 48/2.
Where is that?
That is not in pleading.
Oh.
I'm not saying, even if I don't say that, even if I don't say,
And at your instance, 48/2A
no,
was inspected.
no. My lord, only inspection was carried in premises number 9 as the premises where the defendant and the Devottar property, and 48/2 Thakurghar was inspected.
Yes.
Inspection restricted to
Whose
Thakurghar.
instance?
At my instance.
Why?
My lord, it was
You have
made
not
there.
pleaded that at that place it
My
was.
lord, I cannot travel beyond the record, my lord, that is there. So Thakurghar was
And they
inspected.
want the remaining part of that property to be inspected.
Now, my lord, what
They
happened?
want the remaining part of that property to be inspected.
Yes.
Where the Thakurghar was inspected at your instance.
Yes.
Yes, Mr. Chatterjee. Enough. Asu.
Now, my lord, kindly bear me for a moment. Now, my lord, now what happens, my lord, after this amendment, the personal requirement of the trustees was not was taken out. Therefore, 48/2A, my lord, the entire premises.
Chatterjee, don't proceed very fast, then I have to make observations on this. Paragraph 3 of your plaint, paragraph 16 of your plaint is contradictory. If you read paragraph 3, paragraph 16, it's contradictory as a whole. And from your admission, I can make observations where the DT
Yes,
is
I
situated.
understand. The DT is residing
Where?
there.
Your own statement, pleadings.
Yes. Yes, I can understand, my lord, what is
Yes.
going through my lord's
So
mind.
don't make further submissions. Let an inspection be held.
My lord, kindly then, my lord, keeps that point open, my lord,
What point?
as to the, my lord, whether
If you
this.
don't make any further argument, I will keep that point
Very
open.
good, keeps that.
If you argue further, I will decide that point here and now.
No, my lord, keeps that point open.
Thank you. The order number 70 dated August 29, 2023, passed by the learned judge, second bench, Presidency Small Causes Court at Calcutta, in ejectment suit number 175 of 2016, is under challenge in this application under Article 227 of the Constitution of India. By the said order, the application at the instance of the application under Order 39, Rule 7 of the Code of Civil Procedure, read with Section 151 of the Code, at the instance of the defendant, was allowed. Full stop.
My lord, one statement is there, my lord, for my clarity, my lord, kindly turns to page 23. One statement in the plaint is there, but not mentioning the premises, but what is happening. 23D,
D, yes.
the plaintiff says at present there is no fixed place of worship of Goddess Lakshmi and she is now being worshipped in different
All
personal
the,
houses.
give the particulars of all the personal properties of the trustees. I will direct inspection of all the properties. Give the particulars. Shall you file an affidavit, Mr. Chatterjee?
No.
Giving all the particulars of the trustees, I shall direct inspection of all the properties of the trustees.
No. This much.
Because in all of the properties it is being held. Give particulars, I will direct, you will not be prejudiced for that.
Oh.
Take your seat. No, no, apni na. Mr. Chad. Full stop. Paragraph. Mr. Chatterjee, learned advocate appearing for the petitioner, for the plaintiff petitioner, submits that this is a suit for eviction on the ground of reasonable requirement of the plaintiff DT and premises number 9, Ramtonu Bose Lane, Ramtonu Bose second lane, being only the property of the DT, comma, the learned trial judge ought not to have directed inspection of a property which does not belong to the DT. Yes, this is your submission. First up. He further submits that the learned trial judge, while allowing the said application, did not consider the fact that the personal requirement of the trustees of the DT pleaded in the original plaint was deleted by way of an amendment, which was allowed by the learned trial court. First up. He therefore submits that the inspection of premises number 48 by 2A,
2A.
Ramtonu Bose Lane. This is Ramtonu Bose Lane, not second lane.
Not second, Ramtonu Bose Lane.
The earlier one was
Ramtonu second, Bose Lane second lane.
কি হলো? Ramtonu Bose Lane, কি বললাম? Is not necessary for the purpose of deciding the disputes between the parties. First paragraph. It appears from the record that the plaintiff / petitioner herein filed an application for inspection in respect of one Thakur Ghar on the second floor of premises number 48 by 2A, Ramtonu Bose Lane, under police station Girish Park. And the learned commissioner, after holding commission, has already submitted her report in respect thereto. It further appears from the record that on February 7, 2019, an application was filed under Order 39, Rule 7 of the Code by the defendant in respect of inspection of entire premises number 48 by 2A, Ramtonu Bose Lane, under police station Girish Park. And the learned court below, after hearing both sides, allowed such prayer. That was by order dated 24th of June.
Yes.
Allowed such prayer by an order dated 24th of June 2019. It further appears from the record that on an application under section 151 of the code filed by the present petitioner for modification of the order dated 24th of June 2019 on the ground that the suit property is a trust property and is separate from the properties of the plaintiff, and therefore such property need not be inspected by the commissioner. Full stop. The learned trial judge, by an order dated 7th of November 2019, after going through the records, observed that those properties are also trust properties which are required to be inspected by the commissioner to come to a conclusion in respect of the dispute between the parties. On the basis of such specific finding, the learned trial judge rejected the application under section 151 of the code by order dated November 7, 2019. The petitioner herein preferred a civil order number 376 of 2020, challenging the aforesaid orders dated June 24, 2019 and November 7, 2019. First up, a coordinate bench by an order dated 6th of February 2020 dismissed the said civil order upon holding that the learned trial judge did not commit any error in allowing the application for holding local inspection. First up. However, now the fact remains that though such inspection, Bill to Ghosh held inspection pursuant to this.
Pursuant to this, will not only up to
The
Thakur.
fact remains that the commissioner, namely Bill to Ghosh, inspected the premises in terms of the points contained in the application for local inspection filed by the defendant on
Well, his report is of 14th August 2018, but from the impugned order, I find that before his death, he submitted it on 10th of February 2020.
on on 7/2/2019. However, such report could not be taken on record in view of the sad demise of the learned commissioner in the meantime. Full stop. The
Well, only one correction, pursuant to this order, Bill to Ghosh never inspected. Prior to this, in 2018, he was appointed pursuant to my application. And he inspected premises number 9 and the Thakur Ghar.
Bill to Ghosh did not inspect because in this order, Bill to Ghosh was appointed.
Appointed. Bill to Ghosh was originally appointed on 11th
But
of
Bill to
April.
Ghosh did not conduct any inspection pursuant to the application of the defendant.
No.
Earlier application of the
No.
defendant.
No.
But the order records such.
No, Milord, I've scanned the Milord records. Milord, that's why I was showing. This is the Milord report of Bill to Ghosh, which is on record. And Milord,
Kindly come to Mr. Chatterjee. Kindly come to
yes,
first page of the impugned order, last paragraph.
yes, Milord, that created a confusion in mind. What is happening? Yes, Milord, this application of 7th February for Order 39 Rule 7 was filed at the behest of defendant.
Yes.
But
And the
prior
learned
to
court below, after hearing, has been pleased to allow.
yes,
The learned advocate Bill to Ghosh was appointed to inspect the
Yes.
points
Yes,
And the said
correct.
commissioner has completed his inspection, submitted his
No,
report.
no.
But that is the recording, Mr. Chatterjee.
Well, that's
If
why-
you say that wrong recording, you have to go before the court
No,
below.
that's not wrong, but interpretation, my lord, is Bill to Ghosh. That is on record also. Bill to Ghosh was appointed on 11th of February 2018 at behest of my application. Thereafter, my lord, they filed another application that the entire premises be inspected.
Yes.
Then again, Bill to Ghosh was directed to inspect the entire premises pursuant the 24th of
Entire
June
premises of,
48 by 2A.
yes, that is these premises,
That was passed on 24th.
24th of June. That is what I am saying.
After this order,
24th of June, thereafter modification 151 rejected both these orders challenging civil
after
order.
this, but when after the High Court's order, my lord, he did not further inspect, but
So, on the basis of an order dated 24th of June 2019, did Bill to Ghosh inspect?
no, thereafter he did not inspect. His report is only of 14th August. There is no further report.
14th August of,
2018.
so the report could not be, may not have been filed, but the inspection has been completed. That is the recording.
Yes. My lord, report is
Inspection completed.
inspect.
So, record টা কেটে দিন কি বললাম ওটা না সার্চ রিপোর্ট না করে ওটা কি সেন্টেন্সটা বলুন হবে না তার আগের সেন্টেন্সটা বলুন inspected the premises however due to sad demise of the learned advocate commissioner, no report has been filed before the court. That covers everything. Full stop. Since the issue as to whether the inspection of premises number, the inspection, do you have that the points in that application? That is the same as the current one.
Yes.
In 24th of June or 7th of February, have you annexed that 7th of February?
My lord, 7th of February, yes, my lord.
That petition, earlier petition?
My lord, at the behest of the defendant's applicant,
Yes, defendant.
kindly turns to page 54 of the revisional application.
So that is the current one,
It's current one.
not on the current one, the earlier one.
Yes, my lord, that is in
Or
the
is it the same? Points are the
point,
same.
same.
So I'm relying on this. Point is the entire premises.
Just enter.
The issue as to whether the entire premises number 48/2A Ramtonu Bosch Lane under police station Girish Park should be inspected has already been decided by the learned trial judge on the wide orders dated 24th of June 2019 and 7th of November 2019, which stood affirmed by an order dated 6th of February 2020, passed in CO 376 of 2020. Full stop. Since the full stop. This court is therefore of the considered view that the inspection of the entire premises number 48/2A Ramtonu Bosch Lane is to be done as the earlier commissioner who inspected the premises has in the meantime died. Full stop. This court therefore holds that the order impugned do not suffer from any infirmity warranting interference under Article 227 of the Constitution of India. Full stop. CO number such and such accordingly stands dismissed. The learned commissioner is directed to, today is the date of inspection.
Today is that.
Communicate it to
I have
her,
already communicated. I have already communicated.
is directed to hold the commission in terms of the ordered impugned dated 29th of August 2023 and submit a report as directed by the impugned order.
But only one clarification we made, my lord. Before this commissioner is appointed, another commissioner is also appointed. He has also carried out an inspection.
On your prayer,
On my prayer,
yes, with regard to the Thakurgarh,
with regard to the Thakurgarh and 9,
other things, that is premises number 9, that has been done.
that has been
The
done.
issue is with regard to the, according to you, not a property of the DT, whether can be
So that point we kept open, my lord.
what?
The requirement, my lord, on the final argument that
It's already there, Mr. Chatterjee. What is the report? It's only a piece of evidence which will be considered along with other evidences.
some inured to my benefit. Oh, my lord, this was filed without the certified copy of obtaining a
The certified copy filed in, the certified copy of the impugned order filed in court today by Mr. Chatterjee is taken on record. Mr. Chatterjee, ask your clerk to stitch it. Yes, next.
Item number 51.
51, my lord, I appear on behalf of the petitioner. I am led by Mr. Odilgam Banerjee in this matter. Lord, he is on his legs in court number 10, my lord. That on the last occasion, my lord, this challenge is with regards to an, my lord, rejection of an application under order 711.
Yes, where is
Yes.
Mr. Banerjee?
Lord, he is engaged in court number 10.
Passover,
Lord,
you
not,
want to proceed?
no, my lord, if Passover, my lord, let him argue, my lord. My lord, on
Passover
next
next.
Thursday, my lord, or my lord is fixing it on next Thursday or?
I'm not passing it over. If Mr. Banerjee comes, let me see. Yes,
Okay,
next.
okay.
Passover,
Deeply
sir.
obliged.
Next.
Item number 70.
Seventy. देखिए Passover.
Item number 71.
This side. I'm for the opposite party.
My lord, in this matter, Vijay Shah is on his legs. Kindly short Passover I'm playing.
Yesterday you was.
Yes, he's on his legs. I'm calling him.
Passover.
Please kind.
Item number 72.
72, I am for the petitioner.
Yes, 72.
I am challenging the impugned order dated 20 September 2023 passed by the London Civil Judge Junior Division for allowing the application for order 39 rule 7
Order 39 rule 7 allowed.
allowed. Now kindly see the order impugned
Yes.
last page, before last page only.
What is the suit for?
Suit for that what happened with the
What is the suit for?
suit for declaration.
Declaration of what?
The opposite party filed a suit for declaration. What he is the occupier of the B schedule property of the plain.
What is the B schedule property?
B schedule property, B schedule property is the within the A schedule property.
What is the nature of the B schedule property?
Schedule property is land, my lord.
Where is the plaint? Where is the plaint?
Yes, my lord, kindly.
Plaint is page 14.
Yes, no. This is my. I have filed an application for suit for a suit for a suit.
Where is the plaint? They are plaint.
1 minute. Plaint is page 30. Next
30.
P4, yes.
Yes.
Plate for degree for that the degree of declaration, the plaintiff has every right to use, enjoy, occupy, or possess the peaceful property, noted property without any interruption, objection from any corner, including the different number 1 and his reject.
Yes.
But I have filed a suit for declaration. I am
Give me a minute. Where is the application for local inspection?
Yes. Okay, application for local inspection, my lord, page 54. Now come to the paragraph 6. 55, page 55. That the plaintiff respectfully submits that the preservation of the suit property is highly required. Therefore, the last position of the suit property is required to be brought on into the record by you inspection through a learned advocate for proper and effective adjudication of the suit. They want to collect the missing out of evidence. A learned court below is holding that. Learned court below holding that.
The learned advocate for the petitioner may be justified in arguing that the learned trial judge allowed the application for local inspection without assigning any reasons. Petitioner is directed to serve a copy of this application upon the opposite party herein and file an affidavit of service on the next date. Why you have prayed for stay of suit?
Wait for suit. Impugn order. This is my
That you have not prayed. You have prayed for stay of the suit.
Well, both, my lord. Interim order also must have prayed for, my lord.
Why the suit shall be stayed?
This is my mistake, my lord. Interim order, my lord, I have prayed for.
That you have not prayed for.
This is my mistake. Kindly interim order, my lord.
There shall be an interim order of stay of operation of the order impugned till the end of April 2024 or until further orders, whichever is earlier. List this matter on March 7, 2024.
I'm grateful, my lord.
Yes, next.
At number 73,
I am for the picture.
Yes. Yes, what is the order and the challenge?
My lord, petitioner have actually ordered two orders, my lord.
Yes.
One of rejection of plaint,
Order 7, Rule 11D.
D, and
What is
also
the ground?
and also,
Why the suit is barred?
my lord, what my lord contestation is, my lord, I am placing first list of dates. It is very
Not the list of dates. I'm asking you what is the ground
limitation.
limitation
What happened, my lord?
from the plaint itself. Show me from the plaint
My
itself
lord,
that is barred by limitation.
my lord, return plaint file. Return plaint
Oh,
file,
that matter. Return plaint file. Yes.
not within time.
No. CPC. Yes.
Return plaint file not within time.
That is the order of return of plaint.
My lord, lordship, kindly come to after page 15, my lord.
Page 15.
After page 15, both the order have been annexed, my lord.
Yes. Show me the order of return of plaint.
My lord, return of plaint, my lord, order passed by the learned civil judge junior division,
Yes.
my lord. Let the plaint be on 38 May 2022. Order passed by the learned civil judge junior division additional court Tomlu.
Yes.
Application of penal pass, let the plaint be returned to be presented to the court in which suit should have been instituted with 1 month from the date of this order. Thereafter, my lord, they did not file the suit within the time specified by the learned additional civil judge junior division.
That is the ground under order 7 Rule 11D.
11D.
That is the ground under order 7 Rule 11D.
D, my lord. And also, my lord, section 5 application also filed before the civil judge senior division for condonation of delay. When section 5 has no application for filing the suit before the learned civil judge senior division. It is a fresh suit, my lord. But you kindly see the order.
Have you annexed the order dated 30th of May?
No, my lord. I have not annexed, my lord. I have specifically stated, my lord. paragraph 12, my lord, I have stated, my lord.
But can that be a ground under Order 7, Rule 11D?
My lord, what happened, my lord?
Show me the plain states this fact.
Plain not said this fact.
Then
What happened, my lord? I am coming, my lord. They have,
where is the plain? You have show me that Order 7, Rule 11D, what does it say?
no, this case is different way, my lord. What happened, my lord?
If you want to
They,
invoke Order 7, Rule 11D, it has to be the suit appears from the statement in the plain to be barred by any law.
my lord,
You can
my lord, recently Supreme Court delivered judgment regarding the law of limitation when the suit is barred. Order
show me
7,
that judgment.
and that judgment is a split verdict, my lord. Justice Khanna delivered judgment.
Even can go outside the plaint also.
No, my lord.
Then
Only
I'm asking you that did it say no? The plaint can be dismissed on the ground under Order 7, Rule 11D by taking the defense case of the defendant, by taking the case made out in the application under Order 7.
What happened, my lord?
Or it has to restrict its scrutiny only on
My
the
lord,
statements made in the
I am
plaint.
deeply obliged, my lord. Suit filed on the not on the proper court. After pecuniary jurisdiction, suit has been filed before the.
Follow your point,
Well,
but is it a ground
but
under Order 7 Rule
my lord,
11D?
my
Show
lord,
me that.
my lord, Section 5 does not make any application.
It's a different thing altogether.
That petition has been allowed by the court.
But I
That
am on Order
order-
7 Rule 11 that I will consider.
If,
But Order 7 Rule 11D, what is your sufficient
my lord,
basis?
if the suit is barred by limitation, then my lord, Order 711D is applicable.
First of all, limitation is a mixed question of law and fact, which cannot be decided under Order 7 Rule 11.
That is
Unless I'm adding a rider to that,
my lord.
unless it appears from the statement made ex passive, it's barred by limitation.
My lord.
Then and only then a plaint can be rejected under Order 7.
My lord, I am deeply obliged, my lord.
Cannot
That,
be rejected on the defense case of the defendant.
that judgment is delivered by the Supreme Court. It is a split verdict. Justice Khanna delivered that on the basis of law of limitation, plaint should be rejected on the ground of framing of preliminary issue. And but Justice Trivedi deferred the delivered the different judgment, and in matter refer to the larger bench.
So there are several judgments.
My lord.
You do not have to rely upon the split verdicts.
My
There are
lord,
several judgments on this point.
it has been considered all earlier judgment, my lord.
Show me that it has said no, it can go even beyond the plaint. Does it say so? The judgment which is favorable in
My lord,
to you,
my lord,
does it say even the plaint can be rejected on the basis of the statement of the defendant? Does it say so?
my lord, if it is barred by law, then court can go into that.
Kindly take up.
My lord, Section 22 of the
Do
Hindu.
you have a copy of the Civil Procedure Code? Take
My
it.
lord.
Do you have a copy of the Civil Procedure Code? Take it. Place Order 7 Rule 11D. What does it say?
But here, my lord, suit.
Can you place Order 7 Rule 11D first?
Where the suit appears from the statement in the plaint
Yes,
to be
from
barred
the
by any
statement
law.
in the plaint.
My lord, my
So
lord.
if it has to be strictly interpreted.
My lord.
You have show me from the statements in the plaint, it is barred by law. Yes, I'm with you.
My lord, here, my lord, Supreme Court judgment, my lord, facts is, my lord, transaction appeared in the year 1969. Suit filed in the year 2012. But plaintiff was well aware of the fact that transaction in the year 2008. Supreme Court held, my lord, Justice Khanna held it is a but by limitation. Fact,
And what the Justice Trivedi hold?
Justice Trivedi holds a single judge as well as the division bench of the High Court of Delhi High Court did not take any correct view because of the fact Order 7 Rule 11D, it is a tribal issue. Facts and law and also hold, my lord, the Order 12 Rule 6.
Not 12, Rule 6 is the difference.
Rule 6, the statement must be unequivocal and specifically that should be taken into consideration. And also section 151 of the Code of Civil Procedure.
An interesting point has cropped up in this revision application as to whether civil revision application as to whether the delay in presentation of plaint after the same was returned under the provisions of Order 7 Rule 10 of the Code can be condoned under Section 5 of the Limitation Act. Mr. Petitioner is directed to serve a copy of this application upon the opposite parties by speed post / registered post with acknowledgement due and file an affidavit of service on the next date. Full stop.
I am praying, my lord, stay of the proceedings, my lord.
What is the next date fixed?
Next date, my lord, I could not recollect it.
There shall be an order of stay of all further proceedings in title suit number.
Title suit number, my lord. 11 of 2022, registration.
11 of 2022. Pending before the Learned Civil Judge, Senior Division, First Court, Tomlu, District, Purba Medinipur, till the end of April 2024 or until further orders, whichever is earlier.
My lord,
But you have a
returned.
difficult case in Order 7 Rule 11D.
My lord,
Yes, next.
my lord, Order 7 Rule 11D is a very complicated provision, my lord. Very, very
Yes,
complicated.
next.
My lord, returnable.
Number 74.
Yeah, returnable on March 14,
My lord,
2022.
I am deeply obliged. Under the listed motion, my lord.
I have only one group.
Under
Listed motion,
my lord.
everything is under the same group.
Deeply obliged, my lord.
Yes.
I am for the petition, my lord. Dependent opposite.
What is the order under challenge?
My lord, the two orders under challenge, my lord, the 13th December, my lord, 2022, and my lord, the application for my lord, under 151 application, my lord, water supply water connection has been allowed.
You are a tenant.
No, my
You
lord.
are a landlord.
My lord, there is just, my lord, the plaintiff, my lord, petitioner filed initially, my lord, filed a partition suit. That suit is pending. My lord, suppressing that suit, my lord, they file a fresh suit, my lord, and in that suit, my lord, no hurry, my lord, it has been pleaded, my lord, their partition suit is pending.
What is the next suit? What is the relief claimed in the subsequent suit?
Subsequent suit for declaration, they, I have annexed the both the plaint of the kindly have a look on page 33.
All right, so this is an application in the second suit, subsequent suit.
Yes, my lord.
Subsequent suit, what is the application for?
Application under 151 for application, that application has not been annexed in this in this revisional application.
Permission to have water connection has been allowed.
Kindly have a look.
That is the basic necessity.
No, the premises has already the existing water supply. They are trying to take the water supply.
It is under your control.
The
existing water supply is in your control.
No, my lord. That is not the finding, my lord. They know where it has.
Give me a minute.
Nowhere, my lord, they had stated that. My lord, India suppression, my lord, nowhere it has been stated, my lord, the partition suit is pending. My lord, on the contrary, my lord, came to a specific finding. They are one of the absolute owner, prima facie owner of the
Yes, and what is the other order which you are
Or-
challenging?
my lord, the other one is police help, my lord, the since, my lord, the,
Police help in the matter of water connection.
yes, my lord. No, my lord, they kindly have a look on
You are
the,
saying yes, then saying no.
but kindly have a
Want
look.
to be accepted,
The,
yes or
the
no?
order date, my lord, 13 December order, kindly have a look, my lord, my specific plea, my lord, they are taking, my lord, the water connection, my lord, in the, my lord, my occupied portion, my lord, disturbing my possession, my lord, but that apart, my lord.
That is not your submission. Your submission was that plaintiffs do not have any possession.
No, my lord, they,
It has been recorded. It has been recorded. Aforesaid prayers of the plaintiff is opposed by the defendant in their written objection, alleging that the instant petition is baseless and the plaintiff does not have any possession over the suit property as owners. Is practically trying to get new connection to the occupied portion of the
yes, my
defendant
lord,
number
that,
one, and thereby.
they are not the create, trying to create, trying to dispose me, my lord, by taking, my lord, they have
Why only water connection? You will be dispossessed.
no more. They have challenged. They have challenged my, my lord.
So I am appointing a special officer
But they,
at your cost. So your possession will not be disturbed.
they have challenged, my lord, my deed, my lord, by
You are
which,
agreeable to bear the cost of a special
my
officer.
lord,
Your occupied portion will not be
my
disturbed.
lord, then, my lord, the kindly fix, my lord, and next week, my lord, any day, my lord, I have to take instruction, my lord.
Not instruction.
My
No
lord,
instruction is required. Otherwise, this will follow.
no, my lord. My lord, kindly have a look at the next ultimate paragraph, my lord. The prima facie, my lord, as it appears on the very face of the record that the plaintiffs are claiming their absolute ownership, my lord, without permission, my lord, to how they, my lord, the landed court, my lord, came to a finding.
According to you, this water connection issue is to be decided after the suit.
My lord, the finding of the, my lord, the court, my lord, court below, my lord, the previous, the, my lord, the partition suit, my lord, my lord, in the next suit, my lord, nowhere, my lord, it has been stated, my lord, the partition suit, my lord, they have, my lord, the himself, my lord.
What is the relation between you and your and the plaintiff?
My lord,
What is the relation?
both are, my lord, stranger, my lord.
Both are strangers. More so.
My lord,
So you also do not have any possession there.
no, my lord.
Both have possession.
No, my lord. Initially, my lord, the suit property was, my lord,
Why the partition suit? Why the partition suit?
well, partition suit filed, my lord, they have filed the partition suit, my lord. My lord, kindly have a look at the.
You do not have any share in the suit.
Yes, my lord. They have, my lord, I am the
partition suit claiming to be the co-sharers.
They have filed the, my lord, partition suit claiming the co-sharer. My lord, in the next suit, my lord, they have, my lord, they denied my right title interest. Kindly have a look, my lord. They are plain.
Show me page.
Page 33, and the second suit, page 54 of the title suit of
Yes, 54.
54, my lord, they are claiming, my lord, my gift deed is, my lord, not in enforceable, my lord, they are denying that. Then
We challenge the deed executed in your favor.
yes, my lord.
The ground of the second suit.
I not, my lord, the next, my lord, previous suit, then my lord, they have admitted, my lord, I
purchase the entire suit property or a
no, my lord, they I
purchase the entire suit property or a portion thereof.
Portion 50%, my lord, the 50%, my lord, the 50% owner of the, my lord,
the defendant in a suit for declaration of title and for a further declaration that the deeds executed in favor of the defendant / petitioner herein is invalid, inactive, inoperative, and fraudulent one, has challenged the order number 32 and challenged the order numbers 32 and 41 dated 13/12/2022 and 2nd of August 2023 by filing this application under Article 227 of the Constitution of India, paragraph. The opposite party herein applied for water connection in the suit property, which was allowed by the order dated 13/12/2022, footstep, alleging that the petitioner was creating obstruction in the matter of affecting supply of water to the opposite party herein, an application for police help was filed by the opposite party herein, which stood allowed by order dated 2nd of August 2023. Paragraph. Mr. Chaudhary, learned advocate representing the petitioner, submits that the plaintiffs do not have any manner of possession in the suit property and are trying to
No, no, my lord, they have possession, my lord, in the suit property. My lord, my lord, the schedule.
possession.
Yes, yes, my lord, I'm not saying.
Trying to-
They are trying to, my lord, disturb my possession and trying to, my lord,
Mr.
obtain.
Chaudhary, learned advocate appearing for the petitioner, submits that the plaintiff, that the plaintiffs are trying to encroach upon the portion occupied by the defendant / petitioner herein by way of taking water connection.
Yes, my lord.
He therefore submits that the orders impugned are required to be set aside. It appears from the record that the opposite party has filed a suit for
Two suit, my lord, the one is, my lord, page 27 is the earlier.
filed a suit claiming to be has filed a suit for a declaration that they are the joint owners of the suit property and for a further declaration that the deed of sale executed in favor of the defendant / petitioner herein is invalid, inactive, inoperative, and fraudulent one and not acted upon. The
previous suit, my lord, page 27, my lord, the page 86 title.
The learned trial judge took note of the fact that the learned trial judge, after taking note of the case of the opposite party herein, that there is no water connection in the suit property and they have an urgent need to have water connection in the suit property for their use and enjoyment, and also that they have applied before the concerned municipality to provide for water connection, and the staffs of the municipality came to the suit property on several occasions for effecting water connection, but the same could not be provided due to strong physical obstruction by the defendants / petitioners herein. Observed that the no sufficient materials are before the court to deny a person or deprive the plaintiffs from enjoying the essential service of water supply merely on the allegation of the defendant petitioner. First up, on the basis of such finding, the learned trial judge allowed the petition dated 6th of August 2019 and restrained the defendants from creating any sort of obstruction to the plaintiffs at the time of water connection in the suit property by the staffs, laborers and masons of the concerned municipality. So after hearing Mr. Chaudhary, learned advocate for the petitioner, and after considering the materials on record, this court is of the considered view that there is no infirmity in the order dated 13/12/2022. First up, paragraph. The learned trial judge allowed the application under section 151 of the Code for Police Help for the purpose of implementation of the order dated 13/12/2022.
One indulgence, my lord, the partition suit, my lord, the knowledge trial judge did not consider the pendency of the partition suit, my lord, the same parties, my lord. That, my lord, one observation regarding that, my lord. Page 27 is the, my lord, plaint of that partition suit.
The learned trial judge, after taking note of the fact that an order was passed, that an order dated 13/12/2022 was passed for giving water connection in favor of the opposite parties herein. And after taking note of the fact that the petitioners raised strong objections at the time of effecting the water connection, allowed the prayer for police help. First up, in my considered view, there is no infirmity in the order dated 2nd of August 2023. For the reasons as aforesaid, the civil order number 3472 of 2023 stands dismissed without any order as to costs. Urgent photostat certified copy. Mr. Chaudhary, learned advocate for the petitioner, submits that the instance suit, being title suit number 54 of 2019, has been filed suppressing the fact of pendency of an earlier partition suit.
Filed by the same opposite party.
Partition suit by the opposite party hearing. First up, since the petitioner will be at liberty to take will be at liberty to work out his remedies in that regard in the manner known to law. Thank you. Next.
At number 75.
Eta na last portion ঠিক আগে ঢুকিয়ে দিন। Yes.
My lord, I'm appearing on behalf of the petitioner. My lord, there is a miscase filed in the title suit in the learned court below.
Miscase for what? Under what provision?
My lord,
Miscase or misappeal?
Misappeal.
Misappeal from what order?
For the impugned order, ad interim order.
Ad interim order of injunction?
Yes, my lord.
Miscellaneous appeal is pending?
Yes, my lord. It was filed in 2014 and it is still
Ad
pending.
interim refusal or ad interim allowed?
Ad interim was allowed.
Allowed, against that you have preferred an appeal?
Yes, my lord.
Miscellaneous appeal is ready for hearing?
Yes, my
They
lord.
have appeared?
Yes, my lord. It has been heard partly. The next date for hearing is 31st of January.
31st of January?
Yes, my lord.
What is the date of that order?
My lord, the last date of hearing was 7th December 2023 when it was adjourned, and the next date of hearing has been fixed on 31st of
This is
January.
an application for expeditious hearing of miscellaneous appeal number. For expeditious hearing of miscellaneous appeal number 1201 of 2024, pending before the learned additional district judge, Third Court, Howrah. First up, the learned advocate appearing for the petitioner submits that the miscellaneous appeal is otherwise ready for hearing. First up, she further submits that the next date as next date fixed for hearing of the miscellaneous appeal before the learned court below is
31st January.
31st of January 2024. In view of such submission of the learned advocate for the petitioner, CO 3473 of 2023 is disposed of by requesting the learned additional district judge, Third Court at Howrah, to take up the hearing of miscellaneous appeal number 1201 of 2014, if the same is otherwise ready for hearing, on the next date fixed, that is on January 31, 2024, and to dispose of the same as expeditiously as possible, but preferably on or before the end of April 2024, without granting any unnecessary adjournments to either of the parties.
Grateful, my lord.
Item number 76.
In this matter,
Item 76, my lord. I am for the plaintiff petitioner, my lord. We filed the suit. He is advocate on record, man.
Yes, yes.
My lord, I filed the suit for this is the before your lordship for speedy disposal of a title suit, my lord. It is filed in the year, my lord, 2020, and now, my lord, it is for hearing of WS and WO, my lord. Last 4 years, my lord, they are the defendants.
WO is for injunction application.
Yes, my lord. They are appeared initially. Thereafter, the defendant and not appeared. Matter is fixed for ex parte hearing. Then again ex parte vacating, and there are several adjournments given to the defendant. We are praying that, my lord, the first speedy disposal of the title suit, my lord. In 2020 it was filed, my lord. It is we are appearing all occasions, my lord. And the defendant is not appearing initially. Thereafter, they are not appearing. It is fixed for ex parte hearing. Then ex parte vacated. They are appearing. They are now, my lord, it is fixed for WSW. My lord, tomorrow is the next date for hearing. And, my lord, from the July to July 2023, my lord, under the same order is passed by the court below.
So the injunction application is to be disposed of first. Thereafter the suit.
Yes,
this is an application for expeditious hearing of title suit number 82 of 2020 pending before the learned civil judge, junior division at Jhargram. It appears from the record that an injunction application is still pending, and a date was fixed for filing of the written objection. Paragraph: the learned advocate appearing for the petitioner submits. They have not filed any written objection.
Yes, they are filed, my lord. After yes, my lord, they are filing written objection.
Submits that in the meantime, the written objection to the injunction application has been filed by the opposite party or parties.
Parties, my lord.
Opposite parties herein. Post up. He further submits that what is the next date fixed?
Tomorrow, my lord, tomorrow.
He further submits that 19th of January 2024 has been fixed for hearing of the injunction application. Post up. In view thereof, CO number 3474 of 2023 is disposed of by requesting the learned civil judge, junior division Jhargram, to take up the hearing of the injunction application on the next date fixed, that is on January 19, 2024, if the same is otherwise ready for hearing, and dispose of the same as expeditiously as possible, but preferably on or before March 15, 2024, without granting any unnecessary adjournments to either of the parties. After disposing of the application for injunction, the learned trial judge is requested to dispose of the suit expeditiously.
Deeply obliged, my lord.
Next.
Item number 77.
Made bridge, lordship. Okay. I'm sorry, my lord.
77. Pass over. Next.
Item number 78.
Wait, please, your lordship.
Yes.
Well, I'm having cough and cold, my lord, so I don't have my voices. But the impugned order has been passed, my lord, by the tribunal of the Calcutta Municipal Corporation. But before I make any submission, my lord, I find,
What is the order you are challenging?
my lord, I am challenging the last order that, my lord, your lordship may kindly turn to.
Who are you?
My lord, I am one of the owners of the building, and my lord,
You are the person responsible.
not I'm the person responsible. My lord,
Demolition order has been passed against you.
no, it has not been passed against me. It has been passed against my neighbor, who is my good neighbor. One passage, common passage is being used by both of us. My lord, I filed, my lord, a complaint before the Calcutta Municipal Corporation that my neighbor has made some illegal construction on the common passages. My lord, that was taken cognizance. My lord, a special officer, which is usually appointed by the Calcutta Municipal Corporation, my lord, he conducted the hearing, went through all the papers and documents, etc., and he found that yes, there was some illegal construction.
Demolition order has been passed.
Demolition order passed.
Yes.
Against that, my lord, the private respondent preferred an appeal. Your lordship knows that before the
Yes, yes.
tribunal.
What happened after that?
And my lord, they set aside that order. My lord, what I am humbly submitting at this stage, my lord, to be very candid with your lordship. My lord, interim order, my lord, I should not pray at this stage. Let a direction be passed upon for serving copy upon the Calcutta Municipal Corporation.
Show me the what is the ground on which it was set aside?
Your lordship, kindly see. From page 50 onwards. Your lordship
Yes.
need not go.
Show me the relevant part, the decision
The
part.
relevant part is they say that civil suit was there, etc. Lord, that a reading of the impugned order dated such as the source that the special landed officer has taken the view. The common passage should be treated as a property of the private respondent, and the structure constructed upon it should be removed because, being the owner of the said property, the right, title, and interest of the private respondents has been increased. It is the stated principles of law that the tribunal or the learned disposal officer has got no jurisdiction to adjudicate the right, title, interest of any of the property under dispute. This is the reason which has been taken care of by the tribunal, and the tribunal holds that no, you cannot decide about the right, title, and interest. And it is an admitted position that there is an.
This is the removal of a collapsible gate.
My lord, common
Civil suit
passage.
is pending.
Civil suit, my lord, has, my lord, I have not proper instruction whether it has been disposed of or not. That I do not.
Civil suit is, the tribunal records that civil suit is pending, and
But
records
that-
also an order of the
That was on that day. My lord,
Honorable High Court has clearly been pleased to order that
I
this
have-
construction cannot be removed, because when the order of the civil judge has been passed, then so there is an order of the civil judge
my
also.
lord, may I humbly submit before lordship. That is the reason, my lord, I have prayed before lordship at the very outset. My lord, let there be, my lord, instruction for serving a copy upon the Calcutta.
Why,
Corporation.
Mr. Rai, satisfy me,
My lord, one thing
what is the order of the civil court? The
Lordship,
recording
kindly-
is there,
Lordship kindly adjust for a fortnight, but I will say.
as prayed for by the learned advocate for the petitioner. List this matter after a fortnight.
Because I should not make any such submission, Lord, which
Yes,
is not.
yes. So because if the civil
My lord, yes.
dispute is there, civil suit is there,
My
with regard, and this is an installation of
Certainly,
a
ma'am.
collapsible gate, there has to be a private dispute. Whether it's a common passage or it's a passage exclusively belong to one of the parties. Municipal Building Tribunal cannot decide on such
My lord,
issues. Yes,
My
next.
choice. I'm telling you.
Item number 79.
Yes.
It's an application for expeditious disposal of an eviction suit, Your Lordship.
Judgment একটা দিল, ওই briefটা খুঁজে পাবেন? পাবেন না বোধহয়।
Lordship, expeditious disposal of an eviction suit filed in 2014, Your Lordship.
What is the stage of the suit, madam?
Lordship, Lordship, witness was supposed to start this.
Examination of in chief of OPW.
Yes, Your Lordship. Lordship, the issues were framed. Issues has just been framed.
Why
Yeah.
OPW?
Lordship, that is because there was an interlocutory application, a misapplication, Your Lordship. Lordship, after that, the issues were framed.
That was in 2021.
Yes, Your Lordship.
2022,
Lordship, the last order is in
it has been fixed
2023.
for argument. Argument of 7-2.
Yes, Your Lordship. Lordship, 7-2 has been disposed of in 2023, Your Lordship. The order is there,
Yes.
Your Lordship. In 2023, 7-2 has been disposed of. Lordship, after this application was filed for expeditious disposal, there has been development that the issues were framed and
5th of December for framing of issues.
yes, Your Lordship,
Issues
issues were
have been
framed.
framed.
Yes, Your Lordship. Last Tuesday, that is on the 16th, it was fixed for witness, that is PW1. Lordship, Lordship, there's a
What is the ground of the eviction suit?
Lordship, two grounds mainly, Your Lordship. One is for non-payment of rent, and the other is for subtenancy.
Subletting.
Subletting.
This is an application for expeditious hearing of ejectment suit number 236 of 2014 pending before the learned
Lordship,
judge.
there's a little
Third bench.
misprint, Your Lordship.
Yes,
Lordship, there's a little misprint in the prayer portion. It's written fourth bench. It should be third bench.
third bench.
Yes, Your Lordship.
কি বললাম? Learned judge, third bench, Presidency Small Causes Court at Calcutta. First up, record reveals that 5th of December 2023 was fixed for framing of issues. So the learned advocate appearing for the petitioner submits that issues have already been framed and a date has been fixed for evidence of the plaintiff witness number 1 on
Lordship, it was fixed on 16th of January.
was fixed on what happened? Evidence
Nothing happened.
was fixed on 16th of January 2024 and the matter and the hearing of the suit was adjourned on that date. What
On
is
the
the next
prayer of
date?
the defendant. Lordship?
On the prayer of the defendant.
Yes, sir.
Was adjourned on the prayer of the defendant. What prevented you from filing the affidavit in evidence on that date? Did you file your affidavit in evidence? No.
Lordship, I don't have instruction on that.
What is the next date fixed?
Lordship, not yet. No dates.
First
fixed
up,
yet.
in view thereof, PO number 3477 of 2023 is disposed of by requesting the learned judge, third bench, Presidency Small Causes Court at Calcutta to dispose of the suit as expeditiously as possible without granting any unnecessary adjournments to either of the parties.
Lordship, kindly fix a time frame, Your Lordship.
How much time is required to dispose of an eviction suit? What is your idea about?
Lordship, a 7-2 application was taken 9 years to be disposed of, Your Lordship.
I'm asking you suit. Final hearing, how much time it takes? In
Lordship,
an eviction suit, what is your experience?
Lordship, at least 1 year, Your Lordship. That is a
Thank you. As expeditiously as possible, but
by the end of this,
preferably by the end of December 2024 without granting any unnecessary
that is a
adjournments.
comfortable time.
Thank you. Yes, next.
Order number 80.
Passover, next.
Order number 82.
What's the amp of the petition on it? Well, this is the application for transfer. My lord.
Yes.
Well, this is the application for transfer. My lord. I am the petitioner wife, my lord.
Where to where?
Well,
From where to where?
my lord, transfer from additional district judge Howrah to transfer my additional district judge Arambagh, my lord. My lord, I am the petitioner wife. No direct communication. I am residing at the my lord, Gohat. Also, my lord, opposite party residing at the Gohat. Also, he reside my jurisdiction under the jurisdiction of the ADG Arambagh, my lord.
Criminal proceedings pending?
No criminal proceedings, my lord.
No
No criminal proceedings, my lord. No, already annexed my lord, the matrimonial suit. Copy of the matrimonial suit already been annexed, my lord. The kindly transfer subject to Lordship, my lord.
This is an application for transfer of a matrimonial suit from the court of the learned district judge Howrah to the court of the learned additional district judge additional district judge Arambagh.
My lord.
First up, the learned advocate appearing for the petitioner submits that the petitioner as well as the opposite party are both residents within the jurisdiction of police station Goghat,
My lord.
and therefore the matrimonial suit should be transferred to the court of the learned additional district judge at Arambagh. Petitioner is directed to serve a copy of this application upon the husband opposite party herein by speed post / registered post with acknowledgement due, and file an affidavit of service on the next date.
My lord, next date fixed on my lord, for already noted, my lord.
For appearance,
My lord, for next date fixed, same na, my lord, already been appeared.
Yes.
16th February fixed
for what?
for WO, my lord.
Or written statement.
My lord.
File a written statement.
My lord, kindly short stay, my lord, subject to Lordship, my lord.
This matter on March 7, 2024.
In the meantime, my
Petitioner
lord.
shall file an affidavit of service on the next day. In the meantime, nothing. Yes, next.
Grateful.
At number 83,
Lordship application.
Yes.
Lordship, also an application for expeditious disposal.
This is also an eviction suit.
Yes, your lordship.
Yes, what is
Lordship-
the stage of the suit?
Lordship, issues have been framed. PW1 had started, but then since 2022, the PO is probably on transfer or something. There is no PO, Lordship.
Sorry, court cannot take up the hearing of
Lordship,
these.
Lordship, after filing this application for expeditious disposal, I've also filed an application before the chief bench, small cause court, for assignment of a new bench. That is supposed to be heard on the 22nd January.
So I'm
Lordship, kindly.
postponing this after
Yes,
that.
yes.
Come, if it has been transferred, then
Yes, yes.
an effective order can be passed.
Yes.
On the prayer of the learned advocate for the petitioner, list this matter on March 7, 2022.
Lordship, sometime in February, your lordship.
Obtain an orders. So if that appear before the transferee court, maybe some progress may be had before.
Obliged.
A date will have to be fixed. So collect all these particulars so that an effective order can be passed.
Obliged.
at number 84,
May it please the lordship, my lord. I am the plaintiff and a suit for my lord specific performance, my lord, acceptance of written statement after 1 year without a single line as to the satisfaction, which is totally against the mandate of the provision and also the finding of the Supreme Court.
You want to fight out on the written statement, or you want to your suit to
They
be
are dragging
expedited?
the matter like anything, my lord, kindly see, my lord, that is not the
Sir,
spirit
if you
of the
want to
provision.
fight out on this, time will be consumed for this.
My lord, they have already consumed, my lord,
You want enhancement of some cost.
no cost, nothing.
You want an expertise degree.
No, not expertise. There are
Has to
several.
be-
There
if
are
the written statement is struck
so
off,
far,
then what remains?
well, if the law is
You can
other,
only cross-examine your witness, nothing.
if the law is otherwise, well, I have nothing to say. Well, kindly see the what is the language of the Honorable Supreme Court, Honorable Supreme Court.
All right. So
Kindly
the
see.
suit is to be stayed then.
No, no, my lord, the operation
be.
of the order, my lord.
Has to be, because I cannot proceed. Now it will be proceeding with the written statement. So if the written statement
It
is
is
struck off,
at the initial stage of the suit,
Has
my
to
lord.
be-
It is not the evidence
has to
or
be. Otherwise, now it will proceed with the written statement as on the file. I cannot stay that. Your choice. That is why I asked you.
my lord, no stay as to the my lord the
I appreciate, but until and unless this impugned order is set aside, suit has to be stayed. because it is to be decided whether the suit will proceed with the written statement or without the written
The
statement.
next date is on 1st of March, my lord. 1st of March is the next date.
That is up to you. Show me the impugned order.
The order is typed out with the order number 10.
8th of August is under challenge.
8th of August, my lord.
The order
My lord.
dated 8th of August 2023,
Order number 10.
by virtue of which the order dated 8th of August 2023, by virtue of which the written statement filed at a belated stage without any satisfactory explanation has been accepted. Yes, this is your submission. At a belated stage without any satisfactory reason has been accepted.
And the word, not only the word satisfactory, no reason at all.
Acha, ki bollam? The written statement filed at a belated stage without assigning any reasons for such delay has been accepted by the learned trial judge. Full stop. No. Petitioner is directed to serve a copy of this application upon the opposite parties by party or parties.
My lord, they are the different number 1, 2, 3, my lord. So parties, my lord.
So parties by registered / speed post with acknowledgement due,
As also the learned
and
advocate.
as well as upon the learned advocate on record of the opposite parties herein before the learned court below, and file an affidavit of service on the next date. First up, since the order accepting the written statement is under challenge, this court is of the considered view that all further proceedings in the suit is to be stayed. Therefore, there shall be an order of stay of all further proceedings of title suit number 18 of 2022 pending before the learned civil judge, senior division, Chandanagar, district Hooghly, till the end of April 2024 or until further orders, whichever is earlier. List this matter on March 14, 2024. Yes, next.
So it is the different number 1 and 3 and the opposite party number 1, 2, 3, my lord. 1, 2, 3, my lord.
I said
So-
opposite parties. Sub upon the opposite parties.
Upon all.
Yes, 1, 2,
Because-
and 3. They have
1, 2, rest are also there, my lord. Other defendants, they have filed the written statement, my lord.
they have filed the written statement. তাহলে ওটা না
4 and
শুধু-
5 and 6, they have filed the
শুধু তাহলে তাহলে ওইখানে যেটা বলেছিলাম প্রথমে শুরু করুন বাই দি অর্ডার ডেটেড 8th of August the written, হ্যাঁ বাই ভার্চু কি না না একদম প্রথমে বাই দি অর্ডার ডেটেড 8th of August the written statement filed by the defendant numbers 1 তারপর TO2 3 মানে 1 2 and 3 defendant numbers 1 2 and 3 ঠিক আছে at a belated stage ঠিক আছে আর তাহলে সার্ভিসটা করবেন শুধু serve upon the defendants / opposite parties number 1 to 3 as well as upon their learned advocates.
Item number 85.
Yes,
Item number 85, Your Lordship, Mr. Tanmay Mukherjee is appearing for the petitioner.
yes, you are here. Move.
Yes, Lordship, I am not briefed in this matter.
You are not his chamber junior?
No, Your Lordship.
You are not his chamber junior. Where is his chamber junior? I asked him to argue today.
That I
Where
am
is
not,
he gone?
that I am not.
I'm passing it over. Ask him to come.
Kindly makes it not this week, Your Lordship, because Mr. Mukherjee is engaged in court number 652. Mr. Mukherjee is engaged in court number 652.
Ask him to come at 4:15. Ask him to come at 4:15. Pass over 4:15. Yes, next. Yes, call him.
Item number 86.
Learned Advocate Shirin Hossain is appearing for the petition.
Who is appearing?
Shirin Hossain is appearing for the plaintiff, Your Lordship. She is suffering from severe illness, Your Lordship, so she is unable to come today. Kindly fix the matter next week, Your Lordship, any day.
Pass over. Next.
Matter number 87.
7, my lord, I am for the petitioner, my lord.
Yes.
My lord, I filed an ejectment suit for a reasonable requirement. That was decreed in my favor. The defendant preferred an appeal. In the appeal, my lord, only 2 points matter was remanded. Point number 6 and 7. But my lord, the learned court below, my lord, go beyond the periphery of the jurisdiction, my lord. What was said in point number 6 and 7, the learned judge goes beyond that. And in that application, well, kindly see, my lord, what was the 2 points? 6 and 7.
No. Which order you are challenging?
My lord, I have challenged the order after 50, page number 50, order dated 18th
of August.
18 August, my lord.
Yes.
In one application, my lord, the defendant prayed for my lord to provide him a key. He lost that. Though, my lord, that said room is under lock and key for many years. He was not deciding there. And the learned judge passed an order.
So by the order impugned, the application under order 6, rule 17 was rejected.
Was rejected. I am not agreed for that.
You are not aggrieved.
No,
So you
no,
are
my
aggrieved
lord.
by what portion?
Then, my lord, another order, my lord, he was directed, first page, my lord. After 50, my lord, first page. And now, first, 1, 2, 3, 4. And now 4. In order, this is fixed for argument, both sides file hajira. Page number nahi no?
What is the date of the order?
Date, my lord, 18th August.
Yes, 18th August.
23, my lord. Today is fixed for argument. Both sides file hajira. Defendant number 1 files a petition praying for take out the case from argument board on the grounds stated therein. The petition is heard, considered and allowed. The petition is thus disposed of. Defendant number 1 has also filed 2 separate petitions along with affidavit and photographs. Copies served to the other side. Now the petition filed by the defendant number 1 is taken up for hearing. Had the learned advocate for the defendants who submitted that plaintiff has to put the main entrance door of the said building under lock and key, and the defendant number 1 is unable to have access to the
August you are referring to 18th of August.
18th of August, my lord.
18th of August starts with order number 161.
Order now, yes, order number 161.
It starts with today is fixed for argument.
My lord, now then, my lord, certain development took place. After that, my lord, the judgment was passed on 12th December 2023.
What judgment?
That appeal sued, my lord.
Yes.
That is also decreed in my favor.
Yes.
But, my lord, the point for what I am agreed, my lord, in the my lord, title appeal 124, the appeal was remanded with a direction upon the learned judge to decide only 2 points, 6 and 7. Kindly see that, my lord, 6 and 7. What was said?
No.
Issue number 6 and 7.
Against the eviction decree, an appeal is
pending. My lord.
That is pending. Take all points in the appeal.
No, my lord. That was disposed of.
Appeal
disposed of.
With the judgment of the appeal.
Then, my lord, that was remanded.
When it was remanded? I cannot follow your.
My lord, while kindly come to my lord, page 7.
When the suit was decreed, by what order? What is the date of the
19th December 2019, my lord.
No. Sir, kindly come.
My lord,
kindly, you are placing order dated 18th of August 2023.
My lord.
By this order, the hearing of the application was rejected. Parties were directed to come ready for hearing of the suit.
Suit, my lord.
So, 1st of September, it was fixed for arguments in the suit. What happened on 1st of September?
Thereafter, my lord, the suit was, my lord, heard, argument concluded, and judgment also delivered.
So, where is that judgment?
Net copy. This is the net copy.
The other side has preferred an appeal.
No. Appeal, first time appeal preferred. Then that was remanded back, appeal set aside. The judgment was first appeal. In the appeal, my lord, judgment was set aside. Remanded back.
Sir, what happened after 12th of December 2023? I'm not.
No appeal preferred.
Prior to that.
No appeal preferred, my lord.
So,
I am aggrieved because, my lord, 2 points that when the appeal was remanded, there was direction was to decide.
To challenge this eviction degree.
No. The direction was only to decide only 2 points. My lord, I am coming to that, my lord.
So, you are challenging an eviction decree in your favor on the ground that the same was not passed in terms of the direction passed in the order of remand.
No, but this CO was filed before the judgment.
I appreciate it.
When my lord remand was made, there was direction to decide only two issues,
Yes.
issue number 6 and 7.
Yes.
I am reading issue number 6.
Yes.
Do the plaintiff
Now, according to you, this order has been passed without traveling beyond the scope of that order of remand.
when when the my lord when the learned trial judge was going into the matter, issue number 6 was, do the plaintiffs reasonably require the suit premises for their own use and occupation? Issue number 6. Then issue number 7 was, have the plaintiffs any other reasonable suitable accommodation elsewhere? These 2 points were only decided by were directed to be heard decided by the appeal court, which was preferred by the defendant. But my lord, the defendant in the suit, when that was demanded back, they filed one after another petition. In one petition, he prayed for depositing rent. That was also allowed. Then, my lord, in another petition, he prayed for key. Then another petition, order 6, amendment of order 6 rule 17. My lord, I am agreed because, my lord, such type of, my lord, application should not have been allowed by the learned trial judge. Now, my lord, the judgment is passed and that is in my favor. I am only saying, my lord, that my lord, the order is, my lord, bad in law. The learned judge should not have entertained the petitions.
So you have তাড়াতাড়ি করবেন না তো আস্তে আস্তে। The order number 161 dated 18th of August 2023 passed by the learned Judge, Second Bench, Presidency Small Causes Court at Calcutta in ejectment suit number 237 of 2009 is under challenge in this application under Article 227 of the Constitution of India. So by this, it appears from the said order that the learned trial judge, after rejecting an application under Order 6, Rule 17 of the Code filed by the defendants, directed the parties to come ready for hearing of arguments. And 1st of September 2023 was fixed for arguments. First up, the learned advocate appearing for the petitioner, in his usual fairness, submits that the learned judge, Second Bench, Presidency Small Causes Court at Calcutta has decreed the ejectment suit number 237 of 2009 by a judgment and decree dated December 12, 2023. First up, in view thereof, this application being CO 3487 of 2023 has become infructuous and the same is accordingly disposed of. First up, it will be open to the petitioner to take all points in the appeal if preferred against the said decree.
My lord, grateful, my lord. That also serve my purpose.
What I was trying to impress upon you at the first
My
instance.
lord, that will serve my purpose. My grateful, my lord.
Item
You
number
will allow me
88.
to say that.
Grateful.
Yes, next.
Item number 88.
Well, I am for the petition.
Yes.
My application, my lord, order 26, rule 9 application allowed, my lord, in the year, my lord, 2018. My lord, 11th July 2018. Since then, my lord, no commissioner's report has been filed by the learned commissioner. My lord, one after another adjournment, my lord. Only
Why the commissioner is not filing the
my lord,
report?
there are no disclosure, my lord. My presumption is, my lord, he has been managed by the other side, my lord. Though commissioner's, my lord, application was allowed, my lord, at the instance of the both parties.
The grievance of the petitioner, the grievance of the petitioner is that though the commission was held pursuant to the order passed by the learned trial judge, the commissioner, the learned advocate commissioner,
Yes,
learned
sir.
advocate commissioner has not yet filed the report. First up, it appears from the order dated 26th of June 2023 that 29th of November 2023 was fixed for filing of commissioner's report. Mr. Chaudhary, learned advocate appearing for the petitioner, submits that on that date also, the commissioner did not
File one.
submit the report.
The next date is 17th July, my lord, 2024 one.
You apply for preponing, otherwise.
Yes, yes, my lord, I shall,
Mr. Chaudhary, learned advocate, further submits that the next date has been fixed on 17th of July.
yes, my lord.
17th of July, 2024. Full stop. It will be open to the parties to approach the learned court below for preponing the next date of hearing. Full stop. CO, and if such an approach is made, the learned Civil Judge Junior Division, First Court at Uluberia shall consider the same. Full stop. The learned court below, the learned judge of the court below is also requested to see that the commissioner's report is filed within a reasonable time. Full stop. With the above observations, CO 3488 of 2023 is disposed of. However, the petitioner shall be obliged to forward a copy of this application as well as this order upon the opposite parties by speed post / registered post with acknowledgement due, as well as upon the learned advocate representing the opposite parties in the court below, because we will be applying for preponing.
My lord, the one indulgence, my lord, may I pray, my lord, the disposal of the suit, my lord, within, my lord, since, my lord.
Chaudhary, not at this stage, because the commissioner has not yet filed a report.
Yes.
Nobody knows whether you have to apply afresh. So at this stage, no use.
Great.
Yes.
Item
next.
number 89. My lord, item number 89 is my application, my lord,
Yes.
for the petition. My lord, this is a very simple case, my lord, a probate suit filed in the year 2014, my lord. The first hearing takes place in 2016, mid. My lord, thereafter 72 times the matter was taken up, my lord, 60 adjournments allowed. My lord, this is my case. My lord, a case of 2014, my lord, 2023, it's still pending at the stage of OPW, my lord. My lord, kindly fixes a time frame within which this can be completed, my lord.
Who is responsible for this delay in the disposal of the suit?
My lord, comes to para number 9, I have
No, I'm asking you. Who is responsible for this delay in the disposal, whether it's the presiding judge or any other thing?
My lord, para number 9, my lord would find.
I'm asking you, you did not place the paragraph number 9. I'm asking you, what is the cause for this delay?
My lord, mostly, my lord, 22 times it has been adjourned.
For what?
My
Who is
lord,
responsible? I'm asking you. Whether it's the presiding officer or for any other reason, it is being delayed.
my lord, with all apologies, my lord, 22 times it has been adjourned.
For
With
what?
the note, my lord, with the note that the presiding officer is busy hearing other cases, my lord.
Yes. And
My lord,
kindly come to the order number 68, dated 30th of May, in view of the resolution of the local bar association, order dated 26th
My
of
lord,
22nd of June.
admitted.
All right.
My
So,
lord, my lord,
I will
admitted.
fix a time limit, but it will start from the day when there will be no cease work. You are ready? I will fix the time limit.
My lord, kindly, my lord, kindly.
We will take a resolution not to attend and will say that yes,
my lord,
direct the court below to dispose of this suit within 3 months.
my lord, in that case,
cannot go at the same time.
my lord, in that case, kindly direct no unnecessary adjournments be allowed. My lord, no resolution would be
I shall
affected.
make an observation. If there is no resolution of the bar association, then it will be proceeded with. If on the date fixed, there is a resolution, the time will start run from that date again.
My lord, the difficulty is with the petitioner is no way.
Yes, petitioner, look to the order sheet. Order sheet speaks for
My lord,
itself.
admitted.
So how can you put pressure upon the judicial officer?
My lord, admitted. My lord,
So,
I have come with clean hands.
You do not
Para
have
number
a
9.
control. You also do not have a control over your counterpart. I shall record your undertaking that in spite of resolution, your counterpart will appear. File an undertaking to that effect? Yes, I will fix a time limit.
My lord, that.
Or no adjournment, even if there is a resolution. Either way.
My lord, no adjournments in that case. My lord, kindly record that.
Understand the consequences. Don't make submissions on that. Mr. Banerjee is there.
I'm understanding, my lord.
Submissions after understanding the consequences. Since you are a junior member, that is why I've told you.
My lord,
Look to the order sheet. We are
my lord,
making allegations against the judicial officers, saying, yes, it has been adjourned for so many times. And kindly direct.
my lord, the petitioners are suffering since 2014. My lord, it's been 10 years now.
They are also
My lord,
responsible. I've seen the petitioners have applied for time on many occasions.
my lord, on 7 occasions. My lord, I have come
So
up.
why?
My
Why
lord,
on those occasions you have applied for time?
my lord, on 7 occasions.
Yes. And applications under Order 6, Rule 17 and other things, those were filed, those were disposed of. It's not that it was being
No,
adjourned
no.
from 2014 to
My lord, my
Those orders
submission.
were passed.
My lord, my submission is irrespective of what applications have been disposed of. I am not on that, my lord. Apart from that, my lord.
You have made a detailed calculations, how many dates, how many adjournments. That is why I am telling you. Otherwise, I would not have. 10th of December 2021, petitioner files a petition praying for issuance of summons to witnesses and also files requisites along with process fees. 9th of December 2022, in view of the resolution of the local bar, the case is adjourned for the day.
My lord, that is the difficulty.
So let me
But my lord,
count.
the petitioner
Yes,
in
let me
person
count
is
now
suffering.
on how many occasions this was adjourned on the ground of 21st of August 2021 in view of the resolution dated
My lord,
15th
on
of
16
July.
occasions. I'll come candid to the court. On 16 occasions, it has been adjourned as such, my lord. But my lord, the petitioner in person is suffering, my lord.
Petitioner, 20th of April 2021, petitioner files a petition praying for adjournment on the ground stated therein.
My lord, 7
Each and every
occasions.
order,
My lord,
either local
admitted.
bar association or petitioner.
My lord, even the opposite parties, my lord, even what and what not reasons, my lord, it has been adjourned on 60 occasions, my lord. My lord, I have stated everything in my petition, my lord. Kindly consider that because the petitioner in person is in difficulty. That is the only prayer, my lord.
Ashwin. Before making allegations against the judicial officers, make your submissions in other ways.
My lord, kindly grant, sir.
Because the order sheet reflects otherwise.
My lord, the order sheet reflects, my
Don't
lord.
invite the observations of the court on this.
My lord, the averments are, I have made candid
I
submissions.
have the
with
order
the
sheets. I did not go to your averments. I have the order sheets in front of me. This is an application for expeditious disposal of a probate suit number 3 of 2016 pending before the learned additional district judge within bracket redesignated court Bankura. Full stop. It appears from the record that on several occasions the petitioner prayed for an adjournment. It also appears from the order sheet that the matter had to be adjourned on the ground that the local advocates bar association took resolutions that no adverse order is to be passed, should be passed. Full stop. However, taking note of the fact that the probate suit is pending since 2016, the learned additional district judge redesignated court Bankura is requested to dispose of the probate suit number 3 of 2016 as expeditiously as possible without granting any unnecessary adjournments to either of the parties. ঠিক আছে? ঠিক তার আগে প্যারাগ্রাফে একটা submission record করে দিন. The learned advocate for the petitioner submits that the petitioner shall not pray for adjournment in the court below.
My lord, kindly fix a time frame, my lord.
On this, that is why I have recorded the conduct, why it has been delayed. ওটা ছেড়ে দিন, সাবমিশনটা রেকর্ড করবেন না, মুশকিলে পড়বেন।
Grateful.
হ্যাঁ,
grateful.
লাস্টের এই লাইনটা কেটে দেবেন কিন্তু। Not in this case. I am fixing time limits where it is necessary, not in this case. because I know the reasons.
Grateful. my lord.
For this resolution, I am aware of. CEO disposed of. With the above observations, CEO is disposed of.
Grateful. my lord.
Item number 90.
Madam, 90, I am for the petitioner. The opposite party filed a suit for ejectment against the opposite party. With the so many grounds, one of the grounds is addition and alteration of the suit property.
Yes.
Thereafter, the opposite party filed an application for inspection for engagement of a advocate commissioner,
Yes.
who is not an expert one to inspect the suit property because he is not a skilled man. But the same that said application was allowed.
What is the application for? Show me the schedule of that application. Local inspection or local investigation?
Local inspection, madam.
For what purpose? Local inspection for what purpose?
Whether I have made any addition or alteration to the suit property or not.
All right.
Kindly come to the.
What is the nature of the allegation? Show me first the nature of the allegation with regard to
nature of the allegation? The
addition or alteration. Show me that.
It was stated in the kindly come to page 10.
Additional alteration by raising a pakka wall.
Yes, madam.
Middle of the same.
Yes.
On the room.
Yes.
Divided into part.
Yes. Yes.
So this is the allegation.
Yes.
So whether a room has been, whether a wall has been constructed, for that an engineer commissioner is necessary.
The
According
advocate
to
is
you.
not an expert one, my lord. The advocate is not an expert one, but a skilled man maybe.
I shall remember this when it will come for appointment of a special officer. For this purpose, I will remember this, that no. For that an engineer commissioner.
An advocate.
So you don't have any difficulty if an engineer commissioner is appointed?
Yes, yes, my lord.
Instead of the advocate commissioner?
Yes.
And you are ready and willing to bear the charges of the engineer commissioner?
No, how why should I pay?
That has to be, I will change that.
No,
I will make it an engineer commissioner.
No, my lord.
And provided you pay the fees.
No, but the application has been made by the opposite party. I am questioning myself, why should I pay?
Yes, where is the order?
Kindly come to after my lord, impugned order, after page 26, my lord, after page 26 onwards.
The impugned order, where have you annexed the impugned order?
After 26, the impugned order is.
After 26?
After page 26, my lord, the impugned order is.
Impugned order, sir, it is to be annexed just before the Vakalatnama. That was what we were taught.
My lord, the clerk has.
Clerk has done. Don't put the blame on the clerk. We have signed
I'm
this
not
application.
blaming, my lord. It is
We have signed this application.
My junior, he is absent,
So,
my lord.
it is not his responsibility.
Yes, ma'am. She is also responsible, but due to his personal difficulties, he could not come today. I am appearing. my lord.
Don't put the blame on the
No,
clerk.
no, I'm not. Well, I'm sorry. Extremely sorry, my lord.
Also, do not put the blame on your junior.
No, no, man, I'm not blaming.
Since you are appearing, you have
No,
accepted
it
the brief.
it is my duty to.
Yes. Say so. Yes.
And my lord, kindly come to the prerogative powers that the.
First part is amendment. Amendment, you are not.
No, no, no.
Yes. Ashok. By the order impugned. By the order dated 27th of July 2023, passed by the Learned Civil Judge Junior Division Additional Court Shialda, District 24, Pagona South. The application for amendment as well as an application for appointment of an advocate commissioner under the provisions of Order 39, Rule 7 of the Code of Civil Procedure was allowed. First of the learned advocate appearing for the petitioner submits that the petitioner is aggrieved only with the portion of the order by virtue of which the prayer for appointment of an advocate commissioner was allowed. That's a paragraph. The learned advocate appearing for the petitioner submits that the advocate commissioner is not competent to hold inspection and submit a report on the points on which the opposite party has prayed for holding local inspection. Yes, sir, that is your submission. Paragraph. After going through the plaint, this court finds that the opposite party have alleged that the defendant / petitioner herein, without the consent of the plaintiff landlords, have made addition and alteration of the suit room and raised a pakka wall in the middle of the same on the room by dividing it into two parts. Full stop. Where is the application for local inspection? Yes.
And annexure P3, man.
After going through the page 23.
Oh, man, page 15, man.
Application for local inspection, page 15.
Yes, no, man.
50. Where is the application for local inspection?
Showing, my lord. The page 22, my lord.
Page 22, yes. It further appears from the this application has been allowed in toto.
Yes, my lord.
You have not raised a vital point. Cut. না পুরোটা বলতে ইয়েটা আছে কি বললাম আফটার গোয়িং থ্রু দ্য প্লেন্ট না ওই প্রথমটা ঠিক আছে ওই হ্যাজ চ্যালেঞ্জ তারপরে আফটার গোয়িং থ্রু দ্য প্লেন্ট দিস কোর্ট ফাইন্ডস দ্যাট the suit was for eviction on the ground of default, subletting, reasonable requirement, and unauthorized addition and alteration to the suit premises. After going through the schedule of the application for local inspection, this court finds that the learned commissioner, this court finds that the opposite party has prayed for holding local inspection for the purpose of ascertaining as to whether there is any subtenant or not. Full stop. This court is of the prima facie view that such this court is of the prima facie view that such function could not have been delegated to the commissioner by the court. So the petitioner is directed to serve a copy of this application upon the, you should have told the main point you have saying on advocate, engineer. Unless I went through the plain, I wouldn't have. This petitioner is copy of this application upon the opposite parties by registered / speed post with acknowledgement due and file an affidavit of service on the next date. First up, there shall be an order of stay of operation of the impugned order insofar as holding of local inspection is concerned till the end of April 2024 or until further orders, whichever is earlier. List this matter on March 14, 2024. I was about to dismiss your writ petition application. You are saying advocate commissioner, engineer commissioner, without harping on the main point. Yes, next. Huh? No, porpor dakun. Bahura ebar asche. Porpor non.
At number 91.
Yes. Passover. Call the Passover matters. Yes. Yes, Mr. Banerjee.
Item number 85, Passover matter.
It was fixed of Mr. Banerjee. Yes.
51.
Yes, Mr. Mukherjee. It will not take much time. Banerjee's matter. Yes.
51.
The application, the order of rejection of plaint is unreasoned. It does not have any reason ascribed to it. Please have a look at the order.
Full brief দিয়েছি sure. 51.
Oh, my lord is perhaps 51 টা দিয়েছেন? Oh, my lord is looking at some other brief.
Oh,
Mr. Tanmay Mukherjee's brief.
No, Mr. Arindam Banerjee, what was the item?
51.
51.
51.
Oh, তাই বল। তো রিভিউর উপর হবে।
না। 4:15.
My lord, you are taking a chance. If my lord will allow this, both the applications would be.
Yes.
51.
Yes, Mr. Banerjee.
Application for rejection of plaint rejected. Now, the order impugned does not
Contest
have,
the suit, file your written statement.
absolutely not. Initially, there was a frame of the suit. In that frame of the suit, my lord, it was stated that person who is coming forward is a Borgadar. He came.
The learned court below has relied on Supreme Court judgment,
Twice. And
another
second
Chartered High
last-
Court judgment, and have arrived at a finding. Even then, you are saying it's an unreasoned one.
My lord, there is no reason. There is a finding. Absolutely no reason. The earlier suit that was there, my lord, was
What is the ground for rejection?
ground for rejection was that the plaintiffs who had filed, plaintiff was saying that I am the son of the Borgadar.
Son of the Borgadar, yes.
He does not produce any receipts to show that any cultivation was being carried out at it.
All right, show me the plaint first. What is the prayer?
Yes. Please come to, before that, the first plaint. That
First
plaint was
plaint,
rejected. That was rejected.
All right.
Please
Show me
come.
this plaint.
This plaint is 16, page 16.
Page 60, 60.
16.
16. Yes. Show me the prayer portion.
Permanent injunction alone, page 19, 4 প্রার্থনা নালিশি বুম্মাদি হইতে বিবাদীগণ বাদীকে জোরপূর্বক বেদখল করিতে না পারে।
Plaintiff is claiming to be a Borgada.
He's claiming to be a Borgadar. He has challenged my title deeds. There are title deeds of mine which are within his knowledge. That knowledge is beyond that challenge which he ought to have made in the earlier suit is within 3 years. That's beyond 3 years, not explained. Earlier suit filed for a host of declarations, including perpetual injunction, plaintiff rejected on various grounds. Rejection accepted. Second suit, everyone goes out.
Mr. Banerjee, res judicata, because has those facts been disclosed in this?
No, but this is
So,
where rejection.
judicata
I'm
and
saying
other things,
other
whether
things
it
are
can be taken
trial.
up.
Res judicata completely trial. Suppression, now Supreme Court says no. 7-11 stage, court will look into appropriate suppressed material to see A, limitational bar. 2, if any cause of action is not made out, and or if there is any
Cause of
bar.
action not made out is other
Fine.
thing.
If there is any bar,
That will be respective of the fact that it appears from the statement of the plaintiff.
yes, that will
Other
be irrespective.
documents can be taken into consideration
From
at the time of Order 7 Rule 11.
Yeah, court will forensically look what the Supreme
No,
Court.
Mr. Banerjee, I'm asking you whether the
At,
court.
we all know that is settled. 7-11 only
So
plain.
we are on the 7-11 stage. So you can very well take that point of res judicata at the time of trial. You have to bring those
But in
decisions.
23 Rule 1, I don't think I'm going to get res judicata. 23 Rule 1 withdrawn with liberty to file afresh. He truncates the suit, takes out everything else, takes only a part of the facts.
All things with regard to maintainability
I can take there in the written statement, if at all 14.2 and then.
Now is the Borgada. According to you, the suit at the instance of the Borgada is not maintainable.
According to me, the suit at the instance of the present plaintiff with the limited information that he has given, after he has supplied this information in a prior court-held rejectable plaint.
That Mr. Banerjee has to be at the time of trial.
But this here, my lord, the Supreme Court says that even at this stage, generally that classical law has undergone slight change. My lord is absolutely correct. Only statements made in a plaint to be true and correct. Documents can be looked into. That was subsequently an addendum.
Show me that you have placed that document and the court said no.
Placed the document, the earlier suit.
Yes,
Yes,
in
yes.
this. Show me that portion that yes, submits that the court instead suit is barred by res judicata. That was your submission.
Yes.
Clarifies submitting that.
First, kindly see para 2, internal page 2.
No, the court's finding. I am seeing a court's finding.
All submissions, no finding. Please come down, scroll down. I've seen. No, I mean, come down kindly. Scroll down is a bad habit. Scrolling comes everywhere now. Please come down, my lord, to last but one paragraph. That's only a finding. In view of the facts, in the light of the.
That was given liberty to withdraw with a liberty to file afresh.
Yes, on the same cause of action, he debunked that cause of action. He didn't take that liberty.
That Mr. Banerjee has
that
to
can
be
be that is not res
at the
judicata.
time of trial.
I'm not saying res judicata. I'm saying at this suppression of facts regarding my having acquired title, he's saying I am a stranger. This ordinarily in 7-11 applications, my lords are absolutely correct. Plaint has to be taken to be true and correct, each and every line. Everything annexed, all the documents annexed to the plaint can be looked into. Nothing beyond the plaint, no addition, subtraction, etc.
Mr. Banerjee, the best thing is you have to advise, you file your written statement, then this issue as to whether you are challenging, according to you, he is not a Borgada.
No, he is not a Borgada. He is not a Borgada.
According to you, he is not a Borgada.
No.
So that issue has to be relegated under Order 21, under Section 21(3) of the West Bengal Land Reforms Act.
He was, yes.
So that is the proper course. Order 7, Rule 11. Maybe a difficult.
May I, Lord, request you, Lord, to বসবি আমার সামনে আমন্ত্রণ না বস।
All right, you serve copy, but no stay.
Next date is কবে?
No stay, Mr. Banerjee. I am not convinced with this.
May I just place the judgment?
All right, then I'm keeping it on the next day. Come on the next day. Or you can serve without any stay. All right, not today. করে রাখো।
No, my lord, kindly let him come. There is no stay we don't need for the time being. I'm told it's in the late April. Let it happen.
Petitioner is directed, Mr. Banerjee, learned advocate appearing for the petitioner submits that the all right, Mr. Banerjee, let me consider. Come on the next date. Let me consider. Come with the judgments. I shall decide this.
Lordship, besides this, in presence of them, Lordship is not granting a stay. That will not impair them.
Unnecessarily flogging the list. Yes, call the 4:15 p.m. Fixed matter, yes.
Next Thursday.
My lord, this will again appear next Thursday. This matter will be remanded.
Yes, it will be taken up on Thursdays unless
Unless there is
taken up.
18th Thursday tomorrow.
Yes, yes, yes.
আজকেই করিয়ে নাও না কেউ থাকবো না
Only one. In case it is taken up tomorrow, would your lordship only accommodate me till next Thursday? Next Thursday.
Yes. Mr. Mukherjee, you are not allowing your juniors to go through the briefs. That is the allegation against you. None of your juniors is having a copy of the brief. They are saying.
The copy is very much available in my blood.
Where is your junior on the other day? I asked him to argue. I will not allow you to argue.
But I have not even instructed him to go through the brief so that he can make himself prepared. But
today another advocate was sent for paying an adjournment. I have a very short memory.
No, Lord, it's
but
not that. Lord, I was engaged, Lord, before courtroom number 652, Lord, one partial hearing matter, second appeal was.
But on the last day, I specifically told your junior that I will not allow Mr. Mukherjee to argue.
It's not.
I asked him to be ready in this matter.
I have asked for, Lord, certain document, Lord, which has not been provided.
Yes, 47. Section 47. Yes. Move the matter.
Lord, section 47, Lord, it's a suit for specific performance of contract. That suit is being decreed ex parte. Lord, the 47, the point was the agreement. Lord, I have annexed the agreement. Kindly looks at not one clause of the agreement. Lord, kindly looks at page 17.
Yes.
The second paragraph. প্রকাশ থাকে যে উক্ত জমিতে প্রবেশের যে রাস্তা আছে সেই রাস্তা সম্পূর্ণ মুক্ত অবস্থায় নাই উক্ত রাস্তা মুক্ত হইবার পর হইতে 1 বছর মেয়াদ ধরিতে হইবে আর যদি রাস্তা মুক্ত না হয় তবে বায়না স্বরূপ প্রাপ্ত ৬৫,০০০ টাকা ফেরত দিতে বাধ্য রইলাম so this is a condition contingent to the agreement even if the suit decreed this contingency remains now this suit has been put in this decree has been put into execution. At the execution stage, section 47 application was filed, taking this contingent provision that if that be so, whether the decree can be said to be executed.
Where is the judgment?
Now, no, that is why I have asked for Mr. Roy is there, but today he is not here. But I have asked for the judgment of that the trial judge, so that I can apprise before your lordship this clause whether taken into consideration by the trial court or not. That has not been handed over to me as yet. My application has been turned down at the maintainability stage. The court said, I will not go into the merits. The maintainability itself, this section 47 is not tenable.
Mr. Mukherjee, learned advocate. Mr. Mukherjee, learned advocate for the petitioner, press for an accommodation to file the copy of the. What is the judgment and decree dated?
Actually, 25th of January 2011.
To file the copy of the judgment and decree dated 25th of
January 2011.
25th of January 2011 on the next date. First up, list this matter on March 14, 2024 under the same heading.
Great. Extremely.
Yes.
Your Lordship, just may I permit to just mention one matter? 112 of your 112 of your daily list. My senior already mentioned it today. The date is fixed on.
He got a chance. You mentioned the matter, got the matter disposed of. Ask him.
Not penalize my client for that. Kindly, Lord. Your Lordship knows what had happened. Same matter, Lord. Kindly, Lord.
I've allowed your prayer, Mr. Kormaka.
I do not.
I've upgraded the matter on your prayer.
Second, I say, Lord, that your Lordship had not allowed that. Kindly, Lord. There's some urgency in the matter.
What is the urgency?
Lord, section 34 is being proceeded with, which is per se not entertainable. The matter is being fixed, Lord. On Saturday again, the matter will be.
On Saturday, the hearing will not be closed. If it is set aside, entirety will be set aside.
Some precedence, Lord.
Some precedence.
Lord.
Saturday? If you are ready to come, I will come. This Saturday, when it is fixed? Saturday? At what time?
That is the model.
Morning at what time? I can come before that. 10:30?
আচ্ছা বুঝে গেছি ঠিক আছে
Great.
আমাদের